I wish we all progress and our country progress, our profession progress, and we prosper each and every person of this country. Wish you all happy, healthy, and prosperous New Year. Let's work together for the betterment of the profession, society, and each of us. So let's start with our series of LLP, Masterclass on LLP. First class is on LLP 1, Introduction to LLP and Incorporation of Compliance. So let's today's I would just like to state that our one of the moderator, Mr. Bala, is not available today. First time since years. He is so particular, meticulous. He himself told sorry to everyone because he says that I miss to meet everyone, but he has some other lecture for our institute. So he has requested his absence today. So let's start our presentation, today's presentation, first in 2024. And today we have our one of the panelists is Mr. Thirupal. Thirupal, welcome.
Welcome. Good morning. Good morning to all. Happy New Year. Thank you very much for inviting me.
So, Mr. Thirupal, to introduce, is one of the partners of Thirupal, Thirupal
Gorige.
Gorige. Okay, Gorige and Associates LLP, a company secretary from Bangalore dealing with various corporate law practice. He is fellow member of ICSI. He is also one of the insolvency professional, registered under IBC code with IBBI through ICSI IP. He has handled 3 insolvency cases of IRP liquidator, more than 30 voluntary liquidation. He's been speaker at various forums, workshops, seminars, etc., organized by various institutions, organizations like various chapters of ICSI, ICAI, ICWI, IIM Bangalore, IOD, COE, ICSI, etc. Our other panelist, of course, this is not required. Mr. Bala, as I told today, he's not there, but as you know, he is a veteran and he is having experience of decades and he's worked in Foseco India and then is a regular lecturer. Our another own, Mr. Sudhakar Saraswatula, he doesn't need introduction. I think highest lecture in his account in India, and he is member of CA Institute, CS Institute, and also Institute of Chartered Secretary and Administrator of UK. He was earlier with Reliance Industry. We thank all panelists today's webinar for joining us on our knowledge sharing journey on behalf of entire team of Mehta and Mehta. I would like Thirupal to give, thanks for your time. And, today's topic LLP, we have typically selected. LLP was introduced quite back, but it took momentum recently. It was taking the lead, but the current area, few years, it is picked up. Many people are incorporating LLP. Structuring is happening in LLP, mergers, conversions. But there are many questions to be asked, It's not that everyone has a lot of hang on LLP. There are questions whether unregistered firm can be converted into LLP or registered entity converted into LLP, whether it can be reconverted into again the registered firm. LLP can be converted into private limited company. Private limited again can be converted into LLP. What is the question of merger of two LLP? What is the question of LLP merger with company? What is the situation in case of insolvency of LLP? What is the question of LLP defunct defend? So there are many things which we are going to discuss in this series. and this question will be answered. And I will say that we will discuss and we'll try to find the answers. It's not that always the law is straightforward. There are many things untold. Law is silent. There are many interpretations. So we will detail discussion, and I request all the, I was supposed to ask, I missed that, can a proprietary concern will be also converted? That question also. Thanks a lot, Mr. Pawan. So all these questions we'll discuss, and I request all participants to share their experience. We feel very good when, participant to participants, there is arguments and there is suggestions and arguments with our panelists. That's a healthy discussion, and we really love that at that time we achieved our target. The total participation and concentration and knowledge sharing of each and every participant. It's not one way we want all of you to involve. But however, for better administration and to manage this well, we request all of you to put your questions or comment in chat box. It will parallelly taken with the presentation. And also at the end of the session, if time permits, we allow everyone, the people concerned who raise the hand to unmute and speak. Today, the presentation is given by our partner, Ms. Nayan Handa from Delhi. And thanks, Nayan. And also, I will request Mr. Thirupal to say a few words on the topic, then Mr. Sudhakar, and then Nayan, you can start your presentation. Thanks. Over to Thirupal.
Thank you very much, madam. Thank you very much for the Mehta Mehta.
Nayan, I think you are not on mute. Yes. Yeah. Mute yourself.
Okay, now I will do this.
Yeah. Thank you very much for Mehta and Mehta Training and Knowledge Foundation. The name is suggest. It is really a wonderful opportunity that they are given to me to enhance my knowledge through this foundation. I wish this foundation to flourish in many respects in serving the corporate world. Coming to the topic, as Madam rightly pointed out, now ultimately what is the exactly you are saving? You can do the business in many modes that are available or vehicles that are available. What is that ultimately that you can save? So that is exactly the motivating factor nowadays people are looking. There are maybe some other aspects, but comparatively company and then LLP, the motivating factor right now is the one, there is no dividend distribution tax for the LLPs. And it is a flexi mode. And then especially this LLP agreement, which we file with the MCA, is not a public document. So LLP agreement can be amalgam of regular management in between the LLP partners, and also all commercials can be added in the LLP agreement, because the government, unlike Companies Act, you have a MOA format, forced MOA format, table A, then another forced AOA format like table F. Here they have not given any format. So you can have on your own whatever that you want to have. You can incorporate completely end to end. Like I will give an example. If someone is coming to, venture into your company like a venture capital, then they will, detailedly write your AOA and ask you to modify and file with the public doc. Whereas this case of LLP, you can have that agreement itself as a joint venture kind of agreement. All clauses can be incorporated. You don't need to enter a separate agreement. So that agreement will have binding, and it is not a public document, but still it has a validity in the eyes of the law. Like that, so many advantages are there. So whenever I get opportunity to speak on these aspects, as a panelist, I will keep on talking to. In fact, I did around 150 LLPs, and we did almost all, sort of exercise with the LLP, like converting LLP into companies, company into LLPs, partnership firm into LLPs, and then winding of LLPs, moving of sitting registered office from one state to other state, and change of name, change of object, and change of complete partner, then the death of the partner, then you have foreign partners, and foreign partners being insolvent, foreign partners under the liquidation, how to convert the, move the partners. Almost all aspects I have dealt in the LLP. So whenever I will get a relevant occasion, I will share that knowledge about it. Thank you very much, madam. You can proceed for the regular presentation.
Yeah, Sudhakar, yeah. Sudhakar,
Dipti,
yeah.
yeah, good morning, everyone. In fact, when I was discussing with somebody about inviting him as a panelist, I have been told, "Kibet, do you think that LLP got that kind of a material where you can have a master class of
Yes.
a series of webinars?" I myself got into a dilemma, is it really there or not there? Because let me honestly admit that because working for Reliance Industries, very rarely we want to deal with LLPs are concerned. It is, of course, in case of promoter companies, we used to have some LLPs, but I was not dealing that. Having said that, at the same point of time, being working for Reliance, we have to have the knowledge of every subject. So I do have a knowledge about LLPs. But when I saw the participants today, 345 participants at this point of time, I think this is the highest, if I am not wrong, apart from our CSR series of webinars. CSR, of course, we used to have a lot of people used to join there. But as far as other than CSR, for this Saturday webinars, after I joined and got associated with Mehta and Mehta, seems to be the highest one. 350 people almost joined for LLPs. This shows the importance and significance of this particular subject, what we have chosen. In fact, when I was a company secretary student in those days, we used to have a question always. What are the advantages and disadvantages between a proprietorship concern vis-a-vis partnership firm, between an unregistered partnership firm vis-a-vis private limited company, so on and so forth. So in the year 2000, at that point of time also, that we used to have our own thing that one of the difficulty why people were not incorporating private limited companies, why it was only a partnership firm, is because the compliances in case of private limited companies are more, compliances in case of partnership firms are less. That is one of the reasons. But partnership firms, no doubt, they have its own advantages as well as disadvantages. Somewhere in the 2008, this concept of limited liability partnerships have been brought in, and the act was legislated and enforced. This has brought, to some extent, by that the advantages beyond partnership form and compliance is less than a private limited company. So that kind of another way of incorporating and over and above all, it is a body corporate. LLP is a body corporate under the LLP Act. Because of that, also that your liability is limited. That is the main issue. Number two is that, as I have mentioned, we are going to have about 4 to 5 series of webinars. So we are not going to discuss each and everything today itself, because there is no point of scratching everything. That is the obvious. The purpose of masterclass is whatever the topic we are picking up, we have to go take into a deep dive into that. So as far as the conversions of LLPs into companies, companies into LLPs and all these things, we will not discuss today. So my request to the participants is please confine your questions only relating to today's topic. And today's topic is that to discuss about the significance, importance of the LLPs and the incorporation procedures relating to LLPs. Then in the coming series, that point of time, we will do discuss because now SBO rules are applicable to LLPs also. We need to discuss that at a great length. At the same point of time, no doubt about it. And the Thirupal got a very rich experience as far as conversion of the LLPs are concerned. And for that particular date also, I already blocked him for that. And in fact, I mean that, sorry, before I go further, that I think we are not introduced to the Nayan formally, Dipti, may that today the presentation is being made by Nayan. I think she needs some introduction.
Yeah,
So let me have the privilege of doing that. Okay.
yeah.
So Nayan is a partner of ours from Delhi. She's a very active, vibrant, and dynamic company secretary. A lot of enthusiasm she has. The moment I said that we are conceiving the idea of masterclass on LLPs, and she said that I will do my first presentation. So that kind of an enthusiasm she has shown, and so Nayan is fully equipped, and she got a very beautiful presentation for all of us. And Thirupal, and he's going to be the batsman today, and wherever I require, if I can contribute something, I will definitely pitch it. Thanks very much once again, and Nayan, kindly take over.
Yeah, and today our participants are going to be very active. I know Thirupal, you will be active and questions is already started. And also there will be answers from participants also, I am sure.
In fact, Dipti, let me say that apart from the importance of the topic, I think Thirupal is, in fact, he is the virtually a doyen as far as this subject is concerned. That might be one of the reasons why 382 people are there. If this is the case, then I will say that for all the series of masterclass webinars and LLPs, Thirupal will be the permanent panelist for that.
Okay.
Subject to his availability of time, of course, no doubt about it. Okay.
Yeah.
Yes,
And,
Nayan, please take over.
yeah, please.
So good morning, ladies and gentlemen, esteemed guests, and our participants. I extend a warm welcome to each one of you to the masterclass on Introduction to LLP and Incorporation Compliance. I am CS Nayan Handa, Delhi partner at Mehta and Mehta. So today, Mark, not only we're not discussing about this is not the beginning of our masterclass series on LLP, but also the commencement of a brand new year, which is, filled with the possibilities, growth, and the learning. So it is truly an honor to have you all join us today. So as we, embark on a journey to explore the limited liability partnership and the crucial aspects of incorporation compliances. So your presence here not only shows your dedication to the learning, but also signifies the importance you place on understanding the legal framework that governs the business. So as we step into the first session of our masterclass series, we are not only, dividing into the intricacies of LLP, but doing so with the energy and enthusiasm that a new year brings. So it's a time for a fresh perspective, renewed goals, and the anticipation of accomplishment that lie ahead. So, dear participants, your active engagement and participation is vital in making this session truly enriching. So, please feel free to ask questions in the chat box and share your experience. Let's make this learning experience collaborative and insightful. So, before understanding the concept of LLP, let us understand a brief journey, which is fascinating the history of LLP. So as we explore the concept of LLP, it is very, important to understand that these business entities didn't even just emerge overnight. So their roots back into the 19th century in the Europe. So where we arose for a business structure that could, accommodate the professional partnership like law and accounting firms. So the concept of LLP was then introduced in the United States in the 1990s, and which is making a significant development in the landscape of the business structure. So since their introduction, LLP have steadily gained popularity, offering a unique blend of limited liability protection and the favorable tax treatment traditionally associated with the partnerships. So today, the limited liability partnership have evolved into the highly attractive and versatile business structure, which is catering to the need of entrepreneurship, startup, small business across a wide range of industries. So we are exploring the evolution and advantages of LLP bring to the business world. Without a further ado, let's see the history and the dynamics of the LLP. So here, the story of the LLP begins with the Naresh Chandra Committee Report 2 and the J.J. Irani Committee Report 2005. So these committees recommended the introduction of the provisions for LLP in India. So the wheels were set in motion, and in November 2005, the Indian government released a concept paper outlining the framework for the LLP. So the momentum continued as the LLP bill made its debut in Rajya Sabha in December 2006. the bill underwent scrutiny by the Parliament Standing Committee, and their report was presented to both the Lok Sabha and the Rajya Sabha in November 2007. So based on the committee's recommendation, changes were incorporated into the LLP Bill of 2006. The revised LLP Bill of 2008 was introduced in the Rajya Sabha on 21st October 2008. So this bill, swiftly navigated through the legislative process and gaining approval from the Rajya Sabha in October 2008 and the Lok Sabha in December 2008. So the culmination of this legislative journey occurred when the bill, received the assent of the Parliament President in January 2009. So it's noteworthy that the LLP Act in India draws our inspiration from the UK LLP Act 2000 and the Singapore LLP Act of 2005. So additionally, it is interesting to observe that LLP provisions are not unique to India. So they also exist in the United States, where they were incorporated into the commercial laws and in most states by the United Partnership Act 1996. So Japan too boost its own set of LLP provision. So as we progress, let's further explore the implications. So as we getting into the foundations of the LLP Act 2008, let's start our exploration with the section 1. So this section, though seemingly straightforward, so lays the groundwork for the entire legislative framework which governs the limited liability partnership in India. So the act in its entirely is officially titled as a Limited Liability Partnership Act 2008. So this nomenclature is, encapsulated the purpose of the scope of the legislation. So it's not merely an arbitrary name, but a designation that reflect the legal structure and principles which is under, finding the limited liability partnership. So moving on to the extent of this legislation, it is crucial to note that LLP Act is not confined to the particular region or a state. Section 1, subsection 2, equivocally states that the act extends to the whole of the India. So this broad geographical reach ensures the uniformity of the application of LLP regulations across the country. So equally significant is the aspect of the commencement outlined in section 1, subsection 3. The act comes into the force on a date specified by the central government through an official notification in the official gazette. So this deliberate the initiation mechanism which allows for the systematic and the organized rollout of the LLP regulation. So it is important to note that the central government has discretion to appoint the different dates for the implementation of the various provisions within this act. So this flexibility ensures the phased and efficient integration of the LLP framework into the legal landscape. So as we observe the nuisance of section 1, so this is seemingly introduced the introductory section, which serves as the cornerstone of the LLP Act, setting the stage for the comprehensive and the well regulated legal framework which is governing the limited liability partnership in our nation. So let's turn to section 2, where the foundation of understanding is laid through the key definitions. So today we will unravel a few important definitions, which will provide the shape of which will provide the landscape of the limited liability partnership in India, because there are so many definitions which is given under section 2, and we cannot cover all the definitions. So we are just taking the important definition. The first of all, we are going to discuss about the body corporate. So body corporate is defined under section 2(1)(d), which outlines the dimensions of this term and shedding light on its comprehensive scope within the context of the LLP Act. So it says a body corporate means a company which is as defined in section 4, clause 20 of section 2 of 3 of the Companies Act, and includes a limited liability partnership which is registered organizes category of interconnected nature of the business, which is registered under any law for the time being in force. It can be a recognizing the distinct legal framework which is governing under the Cooperative Societies Act. And third exclusion is any other body corporate not being a company as defined in Section 4, which provides the flexibility for the central government to exclude the certain entities, ensuring the adaptability to the in evolving legal structure. So the definition of a body corporate in Section 2(1)(d) is not merely a static term, but a dynamic concept which gives a spectrum of entities, both domestic and international. So while allowing for a flexibility in inclusions, the business includes every trade, profession, service, and occupation except any activity which central government may by notification exclude. So here we discussing the another term that is defined under Section 2(1)(e) of the LLP Act, which says about the business. As the term business within the LLP Act is all encompassing, and it includes every trade, profession, service, occupation. So this expensive definition reflects the diverse nature of activities that can be conducted under the umbrella of limited liability partnership. However, there is a notable caveat. The definition specifies the term business activities except any activity that central government may by notification exclude. So this provision grants the central government the authority to delimit the scope of what constitutes a business under the LLP Act. So this is a flexibility we can say in recognizing the dynamic nature of the business activity. And as industries evolve, new forms of occupation and services are emerging. So this provision allows for the LLP Act to adapt in the changing economic landscape by excluding the certain activities through official notification. So in inclusion, the definition of business is not a rigid constraint, but a fluid concept that mirrors the ever-changing facet of trade, profession, service, and occupation. So the provision for exclusion ensures that LLP Act remains responsive to the evolving needs of the business environment. So next definition which is going to be discussed is
Nayan, 1 minute. Nayan, just hold it. See, Thirupal, this question comes that suppose if you are a practicing company secretary and an entrepreneur comes to you,
Sir.
ask this question that, look, what kind of I mean, I have to start my business with, okay, is it LLP or a company? Because the way Nayan has mentioned about the definition of the business, you cannot start every business in the form of LLP. So what are the restrictions? And okay, and similarly, when you are advising your client or when you are advising your management, what are the things we have to say? For example, my company is a manufacturing company. What even assembling of parts, suppose into a product, eating the things. Can you deal with that?
Yeah, you can deal with. See, if you look at the business, it is basically inclusive definition. Only few cases, few exceptions, though not here. Like one example is the NBFC activity. Like other regulated businesses, like example, you take the insurance sector. So where the regulator is not providing the licenses for the LLP. If I approach the RBI being an LLP, RBI is not recognizing me to be registered as an NBFC. At the same time, when I approach register of companies to have an object with the NBFC activity, at that particular point of time, the ROC will say that this activity is not allowed for the LLPs. Excluding very few, like those regulated businesses, all other businesses can be carried on through the LLP.
So you mean to say, can I start a manufacturing company also under the form of an LLP?
Yeah, manufacturing also, because it says inclusive. Business is not defined per se. It says includes. It says includes.
Yeah, it is a wide definition because it is an inclusive definition.
Yeah. So you can do it. In fact, if you look at those, the way the LLP Act was, enacted, she has narrated us. Initially, it was there to protect the interest of the professionals who are giving services to the MNCs, having unlimited liability like signing financials, all those stuff. Initially, this concept was there to help the only professionals having a limited liability partnership forms. But government, while making a legislation, they said that let us extend this concept to the all types of businesses. Initially, it was meant only for the CS, CWA, and any other professional who is providing service to the MNC where the unlimited liability will fall on them because of the wrong certification. Or that was the initial, concept. Initially, they agreed, but finally, while making the law, they say let us extend this concept to everyone.
Thirupal, do you have any kind of clients? Say, for example, I'm very particular about this manufacturing process, manufacturing companies.
Yeah.
When I have to set up a factory, I need to have the license from the under the Factories Act.
Yes, sir.
Okay.
Yeah.
Whether when I'm approaching the concerned authorities with a identity as an LLP,
Sir.
are they going to give me the license?
Yeah, they are giving, but initially it was there since they were not aware of the concept. See, the year 2009, 10, 11, we had faced one kind of problem. But now people are recognizing this concept and every regulator is giving the license. In fact, I created one manufacturing unit in the year 2011, I believe. Yeah, it was pure manufacturing unit. And initially there was some problem from the various regulatory. They were unable to recognize the problem was their formats were not having suitable column to fill which entity it is. It is a private limited company, is it a partnership firm, or is it a trust, like that. So that the application was not having a suitable radio button, but subsequently they have modified it. So now we are not facing any problem from any of the regulatories except those NBFC and all.
So Thirupal, with your experience,
Sir.
suppose if a client of yours comes to you and
Yeah.
asks you this question. Suppose, for example, tomorrow I want to start a business activity and I want to start manufacturing something and I want to set up a complete factory for that. And
Yeah.
I am coming to you, asking you that should I set up an LLP, should I set up a private limited company? Which one you prefer and why?
Yeah.
No
See,
doubt about it. You said that under the LLP, this can be done. That is a different thing.
yes.
But which one you prefer and why so?
I prefer, it depends upon the fundraising activity that the gentleman is looking. If the gentleman is looking for the fundraising activity from the like issue of equity, issue of dilution with the giant, what is that, venture capitalist, or someone is bringing, then that concept really will not be useful for the LLP, because the LLP nowadays people are not investing in LLP, especially giant venture. These venture capitalists are not investing in LLPs. Suppose if they are going for only traditional financing like getting the bank and bank loans, I will still suggest the LLP only, because we are getting loans even to the LLPs. Because either it may be private limited company or LLP, without a personal guarantee, no bank will give the loan. So the promoters are providing or extending their own personal assets and their personal guarantee. It may be LLP, it may be company. So they are able to get the fund raised through the traditional manner. Whereas this particular activity is going to be through this venture capitalist or any other angel funding. Still there is a problem that they are not investing in LLP. The reason is that the valuation is very difficult to find out. What is the value. There is no share. How much and then there is another issue also there. In LLP, you can have a different shareholding pattern, means capital ratio can be there, and different profit ratio altogether will be there. A lot of freedom is given to the partners to decide whatever they want. Nothing is regulated in the act. So there is some apprehension in the LLP to invest the money by these venture capitalists.
And also Thirupal, as regards banks also,
Yeah.
LLP per se standalone, not in a group. What is your experience? Because LLP per se also, for bank per se,
Yeah.
they are still always doubtful about,
No, earlier it was there. Earlier really was there. Now this LLPs are being recognized, even banks. I have created even charges also for LLPs, and we filed the charge document. If you look at that LLP 8 intermediate, interval, I think that is the one you have to select, and you can create a charge also. There's no problem from the bank's perspective.
No, I understand. So there are banks who are giving, LLPs getting, but their mindset, it is opened up, and now LLP standalone, not in a group. In a group, it was always available.
Yes.
But in a standalone, it was always reluctancy. Still, that kind of concern when we discuss with bankers, they say that we are little more concerned about LLP because less regulation. The advantage is always a disadvantage also. Whatever advantage we are talking, it's less regulation, withdrawal by promoters, the transparency and all that, the kind of data, information and all that, and we get reluctant, and when the share capital get eroded, we don't come to know. So in that case, I think that I have also discussed with bankers, and what is your experience? And another, my question is about if you want to talk, I think nobody has raised the question about NBFC starting in LLP. Both the
In fact, I've explained now NBFC that RBI is not allowing the license to the NBFC.
Right,
It is NBFC to per LLPs.
because it is.
But there is a you can get the license like alternate investment fund.
Yeah,
I have got one license for one LLP for alternate AIF. So the SEBI is recognized.
Yeah, because it is mentioned NBFC company. They
Yeah.
are telling company, and that's
Yeah.
why it is straight away said LLP is not allowed, because
Yeah, RBI is reluctant to change the definition of LLP.
change the definition also. And this is a standard question many times people ask, why I raise this intentionally. Thanks.
Correct.
We can go ahead and Sudhakar, if relevant questions are there, many are.
I will take up the question. Before that, one more question, Thirupal, is, say, for example, to implement the implementing agency under the CSR rules,
Sir.
it should be a trust or a Section 8 company.
Yeah.
Okay. So can an LLP act as an implementing agency?
In fact, if you look at one of the sections, it says clearly LLP cannot be non-profiting company. That means it cannot be. It says clearly. Similar provision like Section 8 is not there in LLP. Now LLP is only purely for making profit. So
Good.
LLP cannot act as implementing agency for CSR.
So that is what exactly I want to brought out, that LLPs cannot be incorporated like Section 8 or the old Section 25 companies.
Yeah.
So there are a lot of questions are there in this related to that. But before that, I think, let us allow Nayan to move further, and then I will take up the questions.
We will take up, I think, one more question. Someone was asking in the definition of body corporate, he was telling A and B, there is no overlapping. Somewhere it is there. We can take up later. We'll have a reserved question. Yeah.
Yes, Nayan, please go ahead.
Thank you, sir.
I think in that case, we'll take all the questions in the end.
Yeah.
No, not like that. Not like that. Dipti. See, sometimes what happens is that for the sake of connectivity, let Nayan move further a bit. Then we will take up in between.
Okay, fine.
Yeah. So now comes the important definition, which is a designated partner, which is defined under Section 21J of the LLP Act and defines the designated partner. It means a partner designated as such a pursuant to Section 7, which we are going to discuss later. So it is not arbitrary, and it is deliberate appointment, which is outlined by the provision of Section 7 of the designated partners, and it holds the specific role and responsibilities within the LLP. So contributing to its governance, decision making, and overall management. So understanding the role of designated partner, it is really crucial for comprehending the government governance framework of an LLP. So these individuals because plays a very vital role in shaping the direction and functioning of the partnership. So next,
in fact, I would like to clarify here.
Thirupal, one question is that what is the liability of the designated partner? Is it only to the extent of the compliances, or to the business liabilities also will fall on the designated partner? If the partner is not able to discharge the liabilities, is it falling on the designated person?
No, if you look at the act is very clear. Their liability is there to ensure the compliance of the act. Technically, this designated person is not empowered with any authority under this act. He has no power. but he has responsibility to ensure the compliance of the act. Not only this act, maybe any other. Other thing I would like to share with you, the designated partner. In fact, it says clearly, it doesn't say the individual. Suppose there are two body corporates are creating LLP. Both body corporates themselves will be called as a partner and designated partner. The designated partner is represented by an individual. So we should keep in mind this. Which is the forms are designed like that only. The nominee is a representative of the designated partner.
Thirupal, is the designated partner an agent of the partner?
No, he is not an agent of the partner.
So you see that in case of companies, the directors or the like, they are having the fiduciary role they have to play. They are like agents of the shareholder. They are trustees on behalf of the shareholders. Like that, it is there. So what is the relationship between the partner and a designated partner? Number one. Number
Yeah.
two, suppose designated partner is not complying with the act. What is the responsibility and liability of the partner? Anything fall back upon him?
Yeah. In fact, if you look at that, designated partners also being held responsible for non-compliance, and in the absence of their, or if they are not there, even if they are there, they are unable to comply, whatever the reason, it will fall back on the partners. As far as the compliance is concerned, see, we are focusing on compliance. It's not the liability that is created by the partnership. No.
Yeah, correct.
You need to look at the only compliance sake, compliance of the law, compliance of any like income tax returns are not filed, DP is not, filing, then it will fall on the partners.
So if the designated partner is indulging in non-compliances, that liability fall on the partners.
Yeah, absolutely, sir.
Clear. Yes, Nayan, please go ahead. Nayan, you are on mute.
I think. Yeah.
Oh, yes. Thank you, sir. So the partner, our next definition, which we are going to discuss, is about the partner, which is defined under Section 21Q of the LLP Act. It defines, provides the concise yet a comprehensive definition, which is identifying and dynamics of the individual within the LLP. So the definition says in the context of LLP refers to any person who becomes a partner in the LLP in accordance with the LLP partnership agreement. So the definition gives a status of a partner is, which is conferred in alignment with the provision of set forth in the LLP agreement. So this agreement becomes the guiding document which outlines the term, conditions, rights, obligations of each partner within the LLP. So partners in the designated partners in the LLP, they play a very diverse role, which is contributing to its growth, success, operational efficiency. And so this definition acknowledges the varied capacities in which individuals may enter into the partnership. So now moving towards the main definition about the small limited liability partnership. So it is defined under Section 21TA, and it says the small limited liability partnership is a classified which is based on a multiple criteria. So ensuring a comprehensive assessment of its financial dimension, we are discussing about the criteria. So the contribution not exceeding the 25 lakh rupees or such a higher amount, not exceeding the 5 crore rupees as may be prescribed. So the turnover, and the second criteria is on the turnover basis, which says as per the statement of accounts and the solvency for the immediately preceding financial year, not exceeding the 40 lakh rupees or such a higher amount, not exceeding the 50 crore rupees as may be prescribed. So meeting such other requirement which is prescribed under the definition and fulfilling terms and condition which is maybe prescribed. So we can say the small limited liability partnership goes beyond a one size fits for all approach. So it acknowledges and accommodates the diverse financial structure and contributes of smaller entities, which is providing a tailored recognition that aligns with the principles of this definition. So now moving towards the Section 3 of the LLP Act, and this section gives a very essence of LLP and defining them as a unique legal entity in the distinctive characteristics. Section 3, subsection 1, it is establishing that the LLP is not just a partnership, it is a body corporate formed and incorporated under this act. So this distinct legal entity stands separate from the individual entities of its partner. And section 3, subsection 2, gives the LLP a perpetual succession. And this means that LLP continues to exist irrespective of changes in its partner. The concept of perpetual succession ensures the longevity and stability of the LLP. Section 3, subsection 3 is a cornerstone provision which is stating that any change in the partnership of a LLP shall not affect its existence, rights, and liabilities. So this concept, the stability in the face of partner, which is changes, ensures the continuity and the operational consistency. So understanding this section 3 is very important to get the distinctive nature of the LLP, and it gives the reaffirms that LLP is not just a collection of individuals in partnership. It is a legal entity that with enduring stability and continuity. So moving towards the section 4, which signifies that LLP operates within the distinct legal framework, which is separate from the traditional partnership structure, which is outlined in Indian Partnership Act 1932. So this provision, underscores the needs for regulation, which is specifically tailored to the LLPs and recognizing their unique characteristics, limited liability, and the perpetual succession. So in conclusion, we can say the section 4 gives the legal anatomy for the legal liability partnership, and by exempting them from the provisions of the Indian Partnership Act 1932. So their LLPs are granted the flexibility to operate within the framework that aligns with this distinctive feature. Now, leading towards the section 5, which is a pivotal provision that defines the parameters for individual or entities seeking the partnership within the LLP. And section 5 opens up the door to a broad spectrum of the partnership possibilities within the LLP, and it gives the individual or a body corporate to become the partner in the LLP. So, however, there are certain exceptions which is laid out for the individuals, and an individual shall not be capable of becoming a partner if found to be unsound mind by a court or a competent jurisdiction and the finding is in force, or an undischarged insolvent, or if he has applied to be adjudicated as an insolvent and the application is pending before the court. So section 5 promotes a diversity by allowing both the individuals and corporate entities to participate as a partner, reflecting the nature of the LLP structure. And this exception gives the protection to the interest of the LLP and its partner by preventing the partnership that may pose a risk due to the mental incapacity or the insolvency. So we can say section 5 gives a balance between the inclusivity and the prudence by welcoming the broad range of partners while implementing the safeguards, the provisions, and ensures that LLP can benefit from the diverse partnerships without compromising their stability. And
okay,
then,
1 minute, Nayan.
Yeah.
Nayan, there are some questions relating to partners, so let me take up those things. Like Thirupal, can a minor become a partner of an LLP?
No, minor cannot be partner. Partnership form, he can be partner.
So can a corporate become say a partner of an LLP?
Corporate become partner because it is a body corporate.
Okay. Can a HUF through Karta can become a partner of an LLP?
Karta can be a partner. Yeah.
Okay. And how can a designated partner safeguard his personal liability where the designated partner can't even resign, as the case of a private owned company in case of a non-compliance or any other case?
No, the private limited, like private limited company here, this designated partner can resign. There is no problem.
So that means that's the same thing, just like a director, till the time he is holding the directorship, whatever the
Right.
liability is attached to that, he has to face that. And same might be the case with the designated partner also. Am I correct?
Yes, sir. Same.
So how small LLPs are different from LLPs, and what are the pros and cons of both small LLP versus LLP?
Yeah, see, like you have companies like small companies and then other than small companies. So LLPs also they are divided into two, like based on the capital and the turnover. Basically for the compliance and then going to the filing fees will be less compared to the regular LLPs. And similarly, adjudication of penalties and the compounding of fines. In those cases also, the small LLP will be levied off of the fine and penalty when compared to the regular LLPs.
What if there are only partners in the LLP and one partner? There are only two partners in an LLP and one partner expires. What will happen? Will there be a continuity, and within how many days the surviving partner has to appoint a new partner, and whether any fresh partnership agreement is to be entered into?
Yeah, technically the section, if you look at that subsection 3 of the 3, just now she has read, she has explained as well. So even one partner is there, one partner died, then within 6 months to safeguard his unlimited liability, he should bring the partner. And then they should enter into a separate agreement, supplementary agreement should be entered and same should be filed in Form 3 and 4 with the ROC. LLP will
One more
continue.
thing, Thirupal, the disqualifications for appointing as a partner, they are applicable only at the time of appointment, or while continuing as a partner also the disqualification, like suppose if he has become an insolvent in between, what will happen to him?
Yeah,
Whether
if
he will
you
cease to be a partner?
yeah, if you look at the recent amendments made to the LLP Act, wherein they have extended the applicability of Companies Act like 164 and 167 to LLPs as well. So if 167 is there, then he ceases to be, partner or designated partner, depending upon the, disqualification, disqualification that he gets attracted under Section 164. The subsection, whatever Section 5 and sub clauses are there for the individual. Those clauses already there in Section 164, 1 of the Companies Act. And if you are hit by either of the disqualifications during the lifetime of the partner in an LLP, and he will cease to be partner and cease to be DP also, as per 167 of the Companies Act.
So you have mentioned that HUF can become a partner of a LLP through the Karta.
Yeah.
If that is the case, can a registered partnership also become a partner of a LLP through the partner?
Yeah, through the partner can be, any one of the regular partnership firm. Partner can be the partner here on behalf of the regular partnership firm, and you may record the same in your this LLP agreement. And if you look at the recent amendment, I think in September 2023, they have extended the applicability of Section 89 of the Companies Act, that is a beneficial interest, to be filed in form. LLP forms are there, they have extended, still forms are not notified, not in there in online. So you have to file that like in MGT 456 in case of companies that we file, if someone who is holding just registered owner and is not holding the beneficial interest in the shares of the company. Similarly, your LLP case, if it is a partnership firm being a through its partner is a partner, then we are supposed to comply the Section 89 of the Companies Act for LLPs.
So, Nayan, since you have studied while making this presentation, wherever you want to add further to whatever Thirupal says, you may please do that also. Okay.
Sure, sir, sure.
There are 2-3 questions, Thirupal, that still participants are asking the major difference between a partner and a designated partner. Why can't you elaborate it further? Who
Yeah, technically,
is a
see, as
partner, who is a designated partner, their role, responsibility, accountabilities, liabilities. Maybe you may just dwell upon that a bit more.
yeah, partner, like, they have said clearly in the Section 5, partner can be an individual, can be a body corporate. Okay. Suppose you want to create two individuals as an LLP. So both individuals should be designated partners also. See, a designated partner cannot be just designated partner if he is not a partner. First, he should be partner, then he will be put the additional cap called designated partner. Okay. Why the designated partner concept is recognized in the LLP is only for the compliance sake. Someone should be responsible. If you look at the, I think we will dwell upon in some slides about the residential category that needs to be there for a designated partners, not for the regular partners. So what I'm trying to say, partner is basically you can equate to a shareholder of a company, and designated partner to some extent you can equate to the directors and board of directors. However, in case of company, there are sections like 179, the power of the company is vested with the board of directors to do this thing. Those powers are not there in the LLP Act. If you want to give any power to the designated partner, it should be through its LLP agreement. Means partners should agree whether I should give any power to them or not. Right beginning example, they want to appoint a chartered accountant. Whether they can do so? No, they can't do so. They should verify the LLP agreement whether they are empowered to do so or not. So more power is vested with the partners as per the management is concerned. Designated partners are entrusted only the liability under the Act for compliance. Not only under the Act, various other compliances under various regulations. So that is a major difference.
Thirupal, one more counter question. Can I say you meant to say that designated partner vis-a-vis the LLP, do they have the employer-employee relationship?
No, there is no concept of employer-employee relationship. I'll give an example. Suppose you want to pay remuneration to the designated partner. Unless you have entrusted role to perform so many roles, you don't need to pay any remuneration to the designated partner. At the same time, like income tax recognizes the payment of remuneration to the partner if it is recorded in the LLP agreement. You should clearly mention that whether he is entitled to draw remuneration or not. And if he is not entitled to draw the remuneration, even you designate him as a designated partner, that income tax will not recognize if you are claiming some remuneration and taking the exemption from payment of tax, income tax will not recognize. What I'm trying to say, the DP and the LLP has no relation like employee-employer relation. And DP is not something like a whole-time employment in the company, in the LLP. No, there is no such concept of whole-time employment.
Thirupal, you meant to say that, suppose, say, for example, I am not a partner of a LLP.
Yeah.
Okay, that LLP is into some business, just like a managing director of the company, as a whole-time director of a company, or a CEO of a company.
Yeah.
Suppose I join an LLP as a designated partner.
Yeah.
My responsibilities are I have to take care of the business. Okay,
Correct.
like a CEO of a company.
Yeah.
Suppose my designation is CEO designated partner, suppose.
Yeah.
And I will get a remuneration from the company.
Yeah.
So whether that point of time, number one, whether I have the employer-employee relationship with the LLP or not, because this is a very important question. Because when you have the employer-employee relationship,
Yeah.
I will be having certain benefits like your PF, your ESI,
Yes.
maybe superannuation, all these things will be there.
Correct.
And even at my personal taxation also,
Correct.
I will have a different spectrum altogether. That's why I'm asking this question.
Yeah. Correct. See, if anything that you want to do with your employment and employee, you can have an agreement wherein in the agreement you can entrust the power to engage such kind of people through the DPs. You can engage to the DP. You don't need to incorporate. Like suppose you want to have one CEO and DP. CEO is an administrative function. DP is a statutory function. Okay, if you are adding more role to it, either you can add the more role through an agreement or through a board like a resolution. Through a resolution, add that. And if you want to pay the remuneration as per the Income Tax Act, and certainly you need to clearly incorporate his name in the agreement. And if you don't incorporate his name in the agreement, probably if you pay as a remuneration to the partner, then income tax will not recognize you as an expenditure. At the same time, you cannot, that other person, gentleman, if anything that he receives from the LLP is basically his business income, not as a 192 income.
So you meant to say, suppose when we are constituting the LLP, that point of time an agreement has been entered into between the partners. And we also mentioned in the agreement Mr. X and Y are the designated partners. Their role was not envisaged very clearly in the agreement. Subsequently, we want to give them some operational responsibilities also with some kind of a remuneration. You meant to say we have to amend the LLP agreement at that
Yeah,
point of
see,
time?
the one issue, if you want to say take the advantage of the income tax, then you need to incorporate in the agreement. Otherwise, it is not required as per LLP Act. Only as per Income Tax Act, if you want to pay, I think we will discuss it. When it comes to the taxation, like if you make some profit up to 3 lakhs, and in that, 90% can be declared as a remuneration to the working partners. Okay, the balance 10% will be taxed in the hands of the LLP. Suppose you make profit more than 3 lakhs, 60% of the entire profit can be distributed to the partners as a remuneration for the working partners. That means that much profit will be taxed in the hands of the regular partner, hands of the partners, not in the hands of the LLP. So if you want to get this kind of exemption, that you need to incorporate. Assume that if you don't want any of these exemptions, suppose that particular gentleman, I'll give an example. Suppose you have two body corporates coming together and forming an LLP, and there is a officer who is supposed to be nominee of the any one of the DPs, and then he is appointed. Now he is given the entire role of the running the business like a CEO and CFO. Now he is not a partner technically. He is just nominee. So the remuneration payable to him will be as per section 192 of income tax, not as per the remuneration allowed to be deducted from the salaries, allowed to be deducted from the profits. So in such case, you don't need to incorporate any clause in your LLP agreement. What I'm trying to say, for professional employee, you don't need to have any provision at your LLP agreement. For the partner who is also getting, remuneration and also the share in the profit, if you want to take the advantage of the taxation that is given, then his name should be incorporated clearly in your LLP agreement and say he is a working partner, he is drawing this much remuneration. I hope I am clear.
Yeah, absolutely. Thirupal, there is one more question that section 42 of the LLP Act provides that the rights of a partner to a share of the profits of the LLP and to receive distributions in accordance with the limited liability partnership agreement are transferable. Can you please advise us on how this can be practically done?
Yeah, see, I will try to explain. This is similar to the, like, you have a section 123, I think that is a dividend section of Companies Act. There is a subsection 5. In that, there is an order. So, dividend can be paid to the registered shareholder or to his order. That means I can pay as per his direction. Suppose he says you pay the dividend to my wife, I can pay it off. But wife is not a shareholder. But still there is an order from the shareholder, registered shareholder. I can pay the dividend that is declared from time to time to the wife's name. Similarly, in LLP Act, certain rights, especially share of the profits, you will continue to be a partner as per LLP agreement. A share of profit alone can be, transferred to someone else. Distribution alone can be transferred to someone else. That is agreed. And the other person who receives that, like suppose there are divorces, something like that. I want to pay some remuneration to my wife, something like that. That time I can give instruction to the LLP, this much I am transferring the right of the profit to so and so. So this is permitted. That other person will not be a partner automatically. He cannot be partner. He will just receive it like a dividend he receives. This particular gentleman who becomes a sharer of the profits, he will be just sharer of the profits only. He cannot be partner. Without the knowledge of the other partners, he cannot enter into as an official partner into the LLP. So it is the same. The section 42 speaks about the transfer of or partially transfer of your rights to someone else and you will continue to be the partner of the LLP. You will enjoy yourself as a partner, not the other person. So partial transfer of rights is permitted. I will give you in the Companies Act, there are similar provisions are there. Like one example is there, renunciation of rights in the rights shares. That is also kind of transfer of right. Similarly, dividend, I told you,
Right.
dividend you can transfer to someone else by order that is given. Like that. So LLP Act also allows that kind of transferability is there.
Nayan, one question to you. Can the date in the first LLP agreement filed with MCA be on a date before the date of incorporation?
Not getting it, sir. Can you repeat the question?
Can the date in the first LLP agreement filed with the Ministry of Corporate Affairs be on a date before the date of incorporation? That means an agreement, LLP agreement, which was entered into before LLP is incorporated. Is it
No, sir.
valid?
No, sir. It's not valid. I think it is to be
No.
authenticated with the stamp paper.
No.
So
See,
you meant to say first LLP is to be incorporated, thereafter the agreement to be entered into and filed with MCA?
No,
Or
I'm-
can you enter into agreement at the time of incorporation itself and file that agreement along with the incorporation documents? I think that is the question.
The post
Thirupal, what you will say?
agreement has to be filed post incorporation of the LLP
can I
within
clarify?
30 days. Yeah.
Can I clarify?
Yeah.
You can enter an agreement at any point of time before incorporation as well. Like Companies Act, you have a concept called pre-incorporation agreements. Okay. So in LLP Act,
Pre-incorporation contracts. Yeah.
yeah. So in LLP Act also, it is allowed to have pre-incorporation agreements between the partners. The only condition is there, if you look at the even Form 3 as well, you have to ratify them post-incorporation. And you can have an agreement, there is no issue. You can do the business also, you can transfer all the business to LLP also, there is no problem. Any extent you can do that, and post-incorporation, you are supposed to ratify it, all the pre-incorporation contracts by the partners that are there as on the date of registration. Of course, the what you entered post, what is that called, incorporation, that is basically a formal LLP agreement, which you are supposed to enter into within 30 days from date of incorporation on a stamp paper as per the state laws. Few states they have amended to incorporate LLPs also, because the LLP Stamp Act is a physical legislation. Unless you have a specific provision, there is no requirement to pay the stamp duty. So few states they have incorporated and LLP provisions are there. Like in Karnataka, similar to the Companies Act, based on the authorized share capital, means contribution, capital contribution will be paying the stamp duty. It is like every 10 lakhs, 500 rupees we should pay. Our part there are 500 rupees with this unlimited amount. That means each 10 lakhs you are supposed to keep paying 500 like that. So then during that formal agreement, you will endorse all the pre-incorporation contracts and file with ROC. That is allowed.
Nayan, please go ahead.
Yeah.
So now moving forward we are arriving at section 6, which is a foundational provision. Provision that established the minimum requirement for the number of partners within an LLP. So section 6(1) mandates that every limited liability partnership must have at least 2 partners. And section 6 subsection 2 outlines the consequences if the number of partner is reduced below the 2, that the LLP continues business for more than 6 months. So under this reduced number, the sole partner during this period is personally liable for the obligation incurred. So the minimum requirement of 2 partner ensures a foundation of stability within the LLP and promoting the shared responsibility and collaborative decision making. So the provision on liability serve as a safeguard, prevent and undo the burden on a single partner if the number reduces below the stipulated minimum, and emphasizing the collective responsibility of the partners. So section 6 balances the structure and the responsibility of the LLP by setting up a minimum partnership requirement and outlining the liability, which is safeguarding the provisions, ensuring the good framework that encourages the collaborative governance. So here we are going to discuss about the designated partner in section 7, I think, which we have already covered many points of designated partners. So just I give you a brief about section 7, subsection 1. It mandates that every LLP must have at least 2 designated partners who are individuals, and at least one of them must be the resident in India. And the section provides a flexibility for LLP with all the partners being a body corporate. In such a case, at least 2 individuals, either partner or a nominee of the corporate body, shall act as a designated partner. And section 7, subsection 2 outlines the process for the designated partners. If the incorporation document specifies the designated partners, those individuals shall hold the role of on incorporation. So alternatively, the LLP agreement may direct the process of designation and the cessation. And section 7, subsection 3 requires individual to give a prior consent to act as a designated partner with the LLP, filing the particular of each designated partner with the registrar within 30 days of their appointment. And section 7, subsection 4 says every limited liability partnership is required to submit to the registrar the particulars of every individual who has given their consent to act as a designated partner. And this filing must be done in the form, which is form 9, and manner as prescribed by the regulations. And it should be completed within 30 days of the individual's appointment as a designated partner. And section 7, subsection 5 talks about the eligibility to be appointed as a designated partner. It must satisfy the conditions and the requirement which is prescribed by the regulation. So this means that there are specific criteria and a qualification which is giving the regulatory authorities and individuals seeking to become a designated partner. So they must meet that standards to be considered eligible for their role. So section 7, subsection 6 mandates that every designated partner must obtain the designated partner identification number, that is DPIN, from the central government with the provisions of the Companies Act 2013. So applying for this purpose. And in this, I have, one practical challenge which I faced, if LLP wants to add a partner, designated partner as an individual who does not possess a DPIN. So while, getting the DIN for that particular individual is becoming difficult on the MC. I think there is, once we apply the, DIN application form, the LLP, number, it doesn't give the recognition. So we have to apply the DIN through some, private company, and then we get the DPI. And so this is a practical challenge which we are facing for this DIN application once for the fresh individuals to be the partner in the LLP. So anything would you like to, sir, add in this?
Yeah, I think you can proceed. It's fine. Yeah.
Okay. So section 7 is giving a robust governance framework for mandating the presence of DPs, individual responsibilities, and the key functions within the LLP. So here is the form 9, which you can see as a consent is required to take a designated partner for the DPINs. And so before getting into the penalties, let me take you to section 8. Section 8 of the LLP forms of cornerstones, and which gives the outline of the responsibilities and the liabilities of the designated partners within the LLP. And section 8, subsection A, it stipulates that DPs is responsible for ensuring the performance of all the act matters and things which is required by the LLP for a compliance with the provisions of the LLP Act. So this includes the filing of document, returns, statements, and other report which is specified in the LLP agreement. And section 8, subsection B, makes a DPs liable to all the penalties which is imposed on the LLP for any contravention of the provisions of the LLP Act. So section 8, it plays a very significant onus on the designated partners to ensure that LLP compliance is in line with the LLP Act, and they are tasked with the overseeing all the necessary actions and filing to meet the legal requirement. So the provisions covers the, DPs shall be liable for penalty imposed and the LLP in such of, if is there any, contravention of the LLP Act, which we will going to discuss in section 10. So now section 9 of the LLP Act 2008 is, given, introduces a structure of DPs within the LLP. So let's explore the, essence, what it says. Section 9 allows a limited liability partnership to appoint a DP within 30 days of a vacancy arising for any reason. And the provision of subsection 4 and subsection 5 of section 7, which, relates to the consent, filing, and eligibility of the DPs, apply in, respect of the new designated partner. So section 9 introduces the flexibility by allowing the LLPs to adapt to the changes in DPs and ensuring that governing structure remains dynamic and responsive. The application of section 7 provision, which is, maintaining the procedural consistency, it is ensuring the new DPs partner should follow the same regulatory process, which is given in section 7. And section 9 enables LLP to adapt to the, evolving facilitating the appointment of DPs in response to the vacancies arise. So now we are moving towards the most important section, that is section 10 of the Limited Liability Partnership Act, which is serve as a vigilant guardian, ensuring the strict compliance with the key provisions of section 7, 9, and so let's explore the provisions and penalties which is outlined in this section. So section 10 outlines the penalties for the, contraventions of the specific section. And subsection 1 of section 7, right, which is related to the designated partner and which says that every limited liability partnership shall have at least 2 designated partners who are individual and at least one of them shall be the resident in India, which is the LLP is liable to a penalty of 10,000 rupees in case of a continuous contravention of this particular section, and with a further penalty of 100 rupees for each day after the, first during which such contravention continues. So such subject to the maximum of 1 lakh rupees for the LLP partnership and 50,000 rupees for every partner of such liability partnership. So next we can talk about the subsection 4 of section 7, which is related to the consent to act as a designated partner. So, which says like every LLP shall file the registrar the particulars of individuals who has given their consent to act as a DP in such a form 9 and manner as may be which is prescribed within 30 days of his appointment. So under such a limited liability partnership and its every DP shall be liable for such a contravention for the penalty of 5,000 rupees and in case which is a continuing contravention with a further penalty of 100 rupees for each day after the first during which the contravention continues. And it's subject to the maximum of 50,000 rupees for the LLP and 25,000 rupees for its every designated partner. And the third penalty, which is coming under section 10, subsection 3, it is the contravention of provision of section 7, subsection 5, or section 9, which is related to the changes in the designated partners. If the LLP contravenes the provision of section 5 of section 7 and section 9, which is such a LLP and its every partner shall be liable to the penalty of 10,000 rupees. And in case of continuing contravention with a further penalty of 100 rupees for each day after the first during which such contravention continues, subject to the maximum of 1 lakh rupees for the LLP and 50,000 for its every partner. I think so. This penalties are structures based on the nature of contravention with additional penalties for continuing contraventions, and there are maximum limits which is defined for both the LLP and its partner. And section 10 gives a mechanism by imposing these penalties for contraventions, encouraging the strict adherence to the special provisions. So now I think you found this, the inception and foundational aspect of.
Nayan, let us take some more questions. Now, before
sure.
that, let me read one observation of one Mr. Mehta. He says that this is really disturbing there are other participants who are patiently listening, and if such kind of question answers are cropping up every now and then, how can the interest be retained? This looks like a conversation between two persons, but not a knowledge sharing session. This is a bit harsh observation. See, Mr. Nero, let me clarify to you that every webinar has its own pattern. Some people take up the questions at the end of the program. Some people take the questions at an appropriate time. As far as our webinar series, the webinars are concerned, you might have observed that there is a moderator. Today's session, I am actually acting as the moderator. The purpose of the moderator is that then right time, appropriate time, when the presenter is making the presentation, to get more clarity, we always request the panelist to give his observations, to give his value addition. So it is not a conversation between the moderator and the panelist. It is for the benefit of the participants. And you may appreciate that whether Professor Balakrishnan, who is the moderator, he is a very, very experienced and seasoned person. Sometimes he gives his own observations, his own value addition. Apart from that, he asks the panelists also. So today, if I am not wrong, whatever the questions I have put to our panelists today, based on the presentation, I don't think any question is irrelevant. And we are also not gossiping. This is my answer to you. I'm sure that you will appreciate that. Now, let me take some more questions. Can a person who is not a partner of LLP become a designated partner? Of course, this is correct. Already Thirupal has answered this.
Yeah.
Talking of a liability, has any LLP taken?
Sudhakar, 1 minute. Just as regards Mr. Nero,
Yes.
unmuting in starting only I cleared that if we will allow unmuting everyone, all questions, it takes time. But many times what happens, the questions are also repetitive. So we have to combine two question and do this. So that's why unmuting will be done at the end. We will allow all opportunity, don't worry. We always give. Be calm and we really appreciate your interest. You are our member only. So please appreciate. Thanks a lot for your interest. Okay. Unmute will be allowed at the end of the session. Okay. Because then all the, slides are over and then you can cover. Okay. Thanks a lot. Yes, Sudhakar. Sorry.
Yeah. So, Thirupal, talking of a liability, has any LLP taken a T&O liability insurance with any insurance company?
Right now, they are
Or
not
insurance
taken,
company giving such insurance policies?
No, right now I have not observed any company, any LLP taken that kind of policies, but you can take it if the company, that insurance company is there to offer. For them, it is an entity. End of the day, it may be company
And
or
they have more business.
Yeah, that's right.
They will market now.
Yeah, it is available. I think policies
Yeah.
is available. You can take it. There is no problem. But insurance premium will be used.
That is the only issue.
Yeah. Yes, sir.
Okay, there's again one more observation of Mr. Nero Mehta. If this is going to be the format, I would be keen to
No,
leave
he
the
is there.
session.
I think
Please
right.
confirm.
Is there.
He had just asked one question, 11:51.
Hero Mehta, only one sign. Thank you. Yeah.
Okay, anyway, it doesn't matter. I see, because we want to take the criticism also. So people should not think that I'm not taking up this
No, he
question.
had
Let me
asked
take
at
up all the questions.
11:51. One question is there. Can the LLP be formed for an object, which means LLP can be dissolved after the object be achieved? Yes, it can be. We have done some LLPs dissolved also.
This
Now
structure
you have-
is allowed.
Yeah, now it is there. Section 59 of the IBC Act is there. You can dissolve easily. There is no issue.
Okay, Thirupal, one more question. Can LLP agreement amended every time when a new partner introduced or remove old partners?
Yeah,
Is
see
it need to file it with every time with the ROC?
Now the law is very clear. Whoever is becoming the partner of LLP, he should enter into an agreement with the other partner and also the LLP. I've seen this particular provision is exploited by many people. I've seen many LLPs in Bangalore especially. They are not even updating the data of the partners who are joining. They are not even amending the LLP agreement. Simply like a company, you do the allotment. Simply they are just allotting kind of shares they are doing. They are not even filing. There is no form like similar to the past 3. In case of LLP, you have only form 3 and form 4 to update your partners' details. To ensure the more number of partners, recently they have inserted the concept called Excel format also. So you can have unlimited partners entering into the agreement, and the agreement getting filed with the ROC in form 3 and 4. There is no other mechanism that is available in the LLP Act. See, I have just verified section 10 of the Companies Act, whether there is a similar section in the LLP. It is not there. If you look at the section 10, it says that agreement, that MOA entered by the subscriber and subsequently joining the members, it is presumed that they have also signed the MOA and MOA, and once it is registered. That presumption is not there in LLP Act. Whereas people are doing all types of, in one case, I think in Bangalore, there were 2,500 LLP partners. However, they have not filed any of their data with the MCA. And only 2 partners were there as per MCA data. Finally, they found it is a bogus LLP. They collected hell lot of money. Finally, that company was, I think, was called by the CID, CBCID, then some 4,500 crores, something, they raised the money, that LLP, and they all were arrested. People are doing all types of, but LLP Act doesn't allow you to get into this kind of like allotment route, or you enter into like a deed of adherence by the partner. It's not allowed. People are doing, but that means for each entry and each exit of partner, there should be an agreement updation. It can be through a supplementary deed, need not be the entire agreement. You can enter in a supplementary deed, say that, say clause A, B, C is been modified in the following manner. Over. That is my understanding of LLP Act for last so many years. People are doing all types of advice, but if they are not updating the data with MCA, they will be caught tomorrow. Because if you look at the form 11 that you are supposed to file every year before the May 30th, it says clearly what is your contribution, how much you have brought in, what is the liability still. You have to file. But if you don't capture the partner's details, how that return can be filed yearly? Can't file it.
Thirupal, there are 3-4 questions regarding these small LLPs. I'm just combining and asking.
Sir.
The question. Can you elaborate this small LLP contribution not exceeding rupees 25 lakhs and 5 crores? Can you please elaborate? If the contribution of 25 lakhs includes unsecured loans from partners or amounts brought into the business in the form of capital.
Yeah, see, this 25 lakhs to 5 crores. 25 lakhs is the statutory limit that is given in the statute itself to be considered as you as a small company. The 5 crores is the maximum upper limit is given to the government to prescribe, means tomorrow they may enhance this 25 lakhs up to the 5 crores without legislative amendment. They can go up to that. It is written clearly after the 5 crores, it is written as may be prescribed. That means 25 lakhs can be enhanced from time to time. It is more or less that you have the same definition in the small company definition. Look at take the small company definition. It says the same thing. Like today you have 4 crores, then it will go to something like a 40 crores, then you have like that, it is there. So the power is given to the government by making the rules, they can enhance the contribution so that small companies, small LLPs will be more small companies, and more LLPs will fall into the basket of small LLPs. And coming to the loan is not considered to be capital unless you have considered it through your agreement as a capital and file the form 3. Loan will not be considered, so loan is not part of the share capital. And I think one more query is there with respect to the profit that you earn in a year, and if it is not distributed, whether it will be considered as a contribution and all. No, again, for LLP, like similar to the balance sheet of company, you can have a partnership from account, wherein a partnership from capital will be there. Next one is the profit and loss account. That profit and loss account can continue to be there. You don't need to distribute each and every year and credit to the capital. This was exactly is happening. Many CF firms, they are adding every year. Whenever there is a profit will be added to the partner, but they forget to file the form 3 and form 4. And your data will not be updated at the master data. However, your balance sheet will be shown as a capital updated. So whenever you are reclassifying, means moving the profit ratio of profit to the capital, you should file the Form 3. If you don't do, no problem. If you want to move to their regular account, like example, I've seen many balance sheets having two types of heads. One will be the capital, other one will be the current account transaction. So if you want to keep something like current account transaction, there is no provision in the LLP Act to say as a current account. You can have and your own current account, but it is ultimately it is a partner's loan account. It should be adjusted towards that loan account. If you want to adjust, you can adjust it.
Before I ask Nayan to go further, one connected question to that is, will the profit made in a year be considered as contribution made by a partner in the next year if it is not withdrawn? Will this have an effect or impact on the LLP being classified as a small LLP?
Yeah, in fact, I just explained. See, this profit, you can continue to hold it. Why you are not asking the same question when there is a company having 200 crores profit and in the accumulated in the P&L account, whereas your capital is still less than 10 crores. See, we are not adding the profit and loss account for compliance sake. Nowhere is written. Maybe it may be added wherever the net worth definition is there, it may be added, not for the compliance sake.
Okay, Nayan, please go ahead.
Okay, sir. So I hope
just one thing, he sees on, I think 13, which slide and how many slides? And we are at 12:30. We will have 2 sessions for this only now. First session only. Now second session will require. So no issue, we are not rushing, but I think I am drawing the attention. We will not able to complete today, I don't know if we complete, because maximum up to 1:15 or 30, because people we have to allow. So let's close at 1:10 or 1:05 and then allow the people, cover all the question and allow the people for 20-25 minutes to speak.
Yeah.
It's okay?
Yeah, yes, ma'am. I think we have one more part left, that is about the incorporation of the LLP. So I think we can take that in the second part. And now I will cover the basic difference between the partnership and the sole proprietor. So basic things I'll take, and then we will left 10 minutes for the question answers.
I want to allow Mr. Nirav to speak specifically. Okay, chalo.
So I'll take a quick, go through with the slides. So I hope till now you found our journey through this inception and the foundational aspects of the LLP insightful so far. And now we are going to have some little bit exploration about the landscape of what is the difference between the traditional partnership LLP. So our aim is not just to understand the legal framework, but we want to grasp the practical nuisance and set a two business structures apart. So as we transition into this segment, so this is a guide which provide you the shape for every foundation of your business decision. So the traditional partnership have long been the heartbeat of collaborative ventures, fostering agility, and however this business landscape evolves. So does the need of course structure that align with the modern complexities. So let's see the difference between the traditional partnership and the partnership LLP. So here you can see the governing law in the partnership that is defined under Partnership Act 1932, and for the LLP it is LLP Act 2008. And for the registration, we can say in the partnership it is not a compulsory. However, the unregistered partnership firms cannot be sued. So LLP, you can see the registration of the LLP is compulsory with the ROC. And if we talk about the liability, every partner is liable. So jointly for the act or other partner alone or for the acts of them, the firm in the course of partnership. And under the LLP, the liability of partners are limited as per their share of the contribution. So if we talk about the legal entity, the partnership has no separate legal entity, but the LLP has a separate legal entity. And on the enforcement of the act, the Partnership Act provisions are different in various states, as the enforcement of the act is at a state level, and the enforcement of the LLP Act is made by the central government, which is applicable to all the states. And if we talk about the ITRs, no returns are to be filed with the registrar or of firms in the traditional partnerships. And if we talk about the LLP, the annual statement of accounts and annual return has to be filed with the ROC. So the question is already been taken about, can a minor become a partner? Yes, a minor can become a partner in the traditional partnership, but in the LLP, minor cannot become the partner. So having this distinction between the traditional partnership and the LLP, so it is a time to broaden our perspective. So today's landscape covers different structures we have of business. So we are focusing the difference between a little bit of difference between a company, LLP, and the OPC. So as you can say, for the incorporation criteria, the LLP covers under the LLP Act, private companies under the Companies Act, and the OPC again covers under the Companies Act 2013. For the membership requirement in the LLP, there is minimum 2 and maximum, there is no limit in the LLP. For a private company, so the minimum 2 shareholders are required, maximum 200 shareholders. And in the OPC, minimum 1 and maximum can be 1. For directors requirement, 2 designated partners, maximum not applicable, and 2 directors required in the private company. For the OPC, minimum 1, maximum 15. For the capital requirement in the LLP, it is not defined, like there is no minimum capital requirement. And for the private company, no requirement of minimum authorized and paid up capital. And for the OPC, there is again no requirement for the share capital. If capital exceeds 50 lakhs, OPC gets converted to the private limited. Here are the few successful examples of the LLPs in India. So, which is, give you the inspiration from the real world, and where LLP have not only found their place, but you can see how they are excelling and defining the excellence in the various domains. So these success stories and stand as testaments to the resilience and gives adaptability that LLP bring to the business arena. So these LLP shows innovation, adapting to the market dynamics, embracing the change with the resilience. So now, as we are transitioning into the heart of our discussion, so I am thrilled to guide you through the intrinsic features that forms a very, blueprint of success for the LLP. So these features are not just the structural components, but these are the pillars, you can say, which holds the, agility, resilience, innovation, spirit, and that defines in the business world. So limited liability protection. So LLP provides a shield limiting the personal liability of a partners, which ensures that individual asset remains safeguarded from the business liability. And if we talk about the flexibility management structure. So unlike the rigid structure, LLP offers a flexibility in the management. So partners can actively participate in decision making and for the collaboration and the adaptability. So legal status of the LLP is very distinct and from their partners. So this separation ensures the clarity in the matters and simplifies the obligation. In taxation, LLPs are taxed like a partnership, with the profit and losses passes through the partner's personal tax returns. So LLP is a body corporate, we have already discussed, and it is an artificial legal purpose. For all the legal purposes, LLP is an artificial legal person. And for the perpetual succession, I would say we will discuss about this. So in traditional partnerships, if the entry or exit of a partner often trigger a restructuring of the partnership. So in some cases, the dissolution of the entire business. So this can lead to the disruptions, potential losses of the clients, and challenges in maintaining their ongoing contracts. So however, the LLP structure is uniquely designed to address these concerns through the principle of this perpetual succession. So perpetual succession refers to the uninterrupted continuation of the LLP despite the change in its partner. The LLP as a legal entity persists irrespective of the alterations in the ownership structure. So when a partner joins or leaves an LLP, the business doesn't face the upheaval that might be encountered in other businesses structure. So the departure or addition of a partner does not necessitate the re-registration or the restructuring of the entire entity. So perpetual succession provides stability, ensuring clients, customers, and stakeholders that the LLP is a continuous and a reliable entity, and client can confidently engage with the LLP. So knowing that the relationships, agreements will remain intact. So the contract entered into the LLP continue unaffected by the changes in the partner. So this longevity is crucial especially when the LLP is engaged in the long-term projects, so service agreement, or has established the ongoing relationships. So we can say it also facilitate the growth and expansion and attract the new talent, form the alliances, or even admit the new partner without the complexities which is associated with the reconstitution of the entire business. So LLP that have built a brand or a legacy or a perpetual succession ensures that LLP can continue to operate under its established identity. So this is very crucial for maintaining the brand recognition and the market credibility. Here I already mentioned the position is similar to the river where water changes from time to time, but the river is same. Or a nation where individual citizen changes, but the nation is the same and continues with the same identity. So thus the change of a change or a death of some or even all the partners, it does not affect the continuity of the LLP. So here are some case laws which is related to the perpetual succession. And in the first case by the Guildford Limited, in this case, during a wartime bombing incident, all the members of the private company were, tragically killed during a meeting. So the company, however, survived unscathed, and the court emphasizes that the company, being a separate legal entity, remained intact, even when it is a members met such a tragic fate. So this vividly illustrates the principle that the existence of a company is distinct from the life of its members. And another, there is a case of Amit Product India Limited versus Chief Engineering, which, this case underscores that a merger, mere change in a directors or an alternative in the shareholding pattern does not transform the company into the different entity. So the Supreme Court emphasized the continuity of the legal entity despite the change in the composition of its management or the ownership. So this ruling is crucial in establishing the resilience of the company's identity. In the third case, Memtech Limited versus Lunarmec, it says in this case, even after the transfer of shares and a change in the name of a company, the court affirmed that continued existence of the company as a distinct legal entity. And the judgment has highlighted that alteration of the company's name or a change in ownership does not, nullify its legal entity. So the court's decision ensures the legal proceedings initiated in the company's previous name can still be pursued, emphasizing the continuity of its legal existence. So as this is another features of the LLP, that LLP agreement is prescribed under Section 2 of the LLP, which means a written agreement between the partners of the LLP or between the LLP, its partners, which determines the mutual right and duties of the partners and their rights in the relation to the LLP. And common seal is another feature. If the partner decided the LLP can have a common seal under Section 14C, it is not mandatory though. However, if it is decided to have a seal, then it is necessary that the seal remains under the custody of the responsible official. And the limited liability is defined according to Section 26 of the Act. Every partner is an agent of the LLP for the purpose of the business of the entity. However, he is not an agent of other partners. So further, the liability of each partner has limited to his agreed contribution to the LLP. It provides a personal liability protection to its partners. So as we are moving towards the panoramic view of the possibilities of the LLP with their unique structure, which offers the different kind of advantages that only protect your business, but it also give you towards a new horizon of the growth, flexibility, and the resilience. As you can see in this advantages, it is a separate legal entity and you can raise the funds from the partners. And in LLP, where a partner is not liable for all the losses of the company, and the partners of the LLP have the right to manage the business directly. Most incorporation an LLP can have the limitless partners. And if there is only one partner in an LLP, then the sole partner can find a new one without dissolution. So here are some advantages we are going to discuss about. There is no requirement of the compulsory audit. If we say all companies, whether private, public, or irrespective of their share capital, are required to get their accounts audited, but in the case of LLP, there is no such mandatory requirement. This is perceived to be the significant compliance benefit. A limited liability is required to get the tax audit done only in the case that the contribution of the LLP exceeds 25 lakhs or the annual turnover of the LLP exceeds 40 lakhs. Another advantage is no requirement of the minimum contribution. So there is no minimum capital requirement in the LLP, and it can be formed with the least possible capital. So moreover, the contribution of a partner can consist of a tangible, movable, or property to other benefits of the LLP. So there's another advantage that dividend distribution tax is not applicable in the case of a company. If the owners to withdraw the profit from the company, additionally tax liability in the form of DDT at 15% is payable by the company. However, no such tax is payable in the case of LLP, and profit of an LLP can be easily withdrawn by the partners. So taxation aspect on the LLP for income tax purpose, LLP is treated on a par with the partnership firm. So thus LLP is liable for the payment of income tax, and share of its partner in partners is not liable for the tax. So thus no dividend tax is payable. Provisions of deemed dividend under the income tax is not applicable to the LLP. After discussing all the advantages and features of the LLP, we can explore some that every structure comes with its own set of challenges. And while LLP offers a numerous advantages, it is essential to have a see like how many influence your business decision, and let's navigate like how there are few disadvantages which ensuring that you are equipped with the comprehensive understanding. There are certain business restrictions, like LLP may be subject to the certain business restriction depending on the state or a country where they are formed. Unlimited liability for the wrongful act. LLP partners can still be held personally liable for their own wrongful act and the negligence. Potential for management conflicts. You can say the LLP with the multiple partner may face conflicts in decision making, management, potentially leading to the dispute and even the dissolution. Here comes the another disadvantage is like inability to have an equity investment. An LLP does not have the concept of equity or shareholding like a company. Hence, the angel investors, HNIs, venture capital, private equity fund cannot be invest in the LLP as a shareholder. So thus most LLP would have to rely on funding from the promoters and the debt fundings. Penalty for the non-compliance, even if an LLP does not have any activity, it is required to file the income tax return on the MC annual return each year. So in case an LLP fails to file Form 8 or Form 11, a penalty of 100 rupees per day is applicable. So there is no cap on the penalty, and it could run into the lakhs if an LLP has not filed its annual return for few years. Also, there is a higher income tax return rate. So the income tax rate of a company with a turnover of rupees 250 crore is 25%, further reduced in 2019 for a new companies involved in manufacturing. However, the LLP are taxed at 30% rate irrespective of the turnover. So here are some additional facts about the LLP, like the provision of the LLP shall be addition to not in derogation of the provisions of any other law for the time being in force, section 71 of the LLP Act. So LLP Act does not override any other law, and LLP Act applicables to the whole of India. And LLP rules are notified from 1st of April 2009, and these rules also contains the provisions which is relating to the conversion of a firm or a company to LLP. And these rules have also been made effective from 31 May on 2009. LLP winding up and dissolution rules 2012 notified on 10th 7 2012 make a provision for winding up and dissolution of LLP 1. So these are some of the provisions of Companies Act which is applicable to the LLP, like Section 19, Register of Significant Beneficial Owner in the LLP. Section 164, disqualification for appointment of designated partner. 165, number of directorship, vacation of office. Central government can direct inspection of books and papers of a company by the inspectors. And Section 207 about the power of inspector during inquiry. Section 252, appeal to NCLT, and Section 439, offences and non-cognizable, and with complaints from the registrar or a partner. So for the incorporation, we will take this session in the second part. I think now we can open the round for the question and answers.
Yeah.
Over to you, Sudhakar sir. Yeah.
There are some more questions are there in the chat box, which I will be taking first, and after that we will ask the participants to speak up. And Thirupal, one question is, please provide inputs on whether a partner can sell his share in an LLP.
Yeah, it is, see, selling the share is nothing but is exiting the partnership form. Isn't it? So he needs other partners' consent. See, partnership form is something like it runs based on 100% consent formula. It's not like a company where you can even you look at the private limited company, share transfer is restricted in the manner provided in the articles. Okay, you have to offer to the existing shareholder, or if it is between family members, there is some exceptions will be there. Similar to that, the transfer provisions will be there in your LLP agreement. And like you want exit from LLP, you can offer to the existing partners, or you can bring new partner depending upon the consent of the other partners.
Basically, you have to cover in the agreement. So when
Yeah.
LLP agreement is drafted, though it gives freedom, that itself make you responsible to predict all the situation in which you want to be governed. And you should be predicting each event which you want to provide so that it will be governed by that. Yeah. Yes.
If I have a CS partnership form, can I form LLP with other company secretaries and me as a partner of the firm?
You can be proprietor concern also, and same time you can be partner in other firm. I don't think any permission is needed from institute.
Okay, there are some questions about the conversion, about foreign investment and all, which we will take up in the next webinars when that particular series we are organizing it. Okay.
I think few questions like distribution tax, someone was telling DDT was abolished, but it is now taxable in the hands of the shareholder.
So this tax related things, Thirupal, I thought we will take up when we are talking about the tax related aspects of LLPs,
Yeah.
Can a person who is not a partner be given a share of the profits as well?
Yeah, it can be. I think we have discussed about that 42 section. It allows you.
Section 64 clubbing provision will be applicable if transfer of profit.
Yeah, someone was telling that if DP wants to, pay his remuneration to his wife. 64 of income tax.
Does a stamp duty required to be paid against if new partners are bringing in new capital and old partners are resigning with taking their capital? Please explain the stamp duty aspects.
Yeah. See, stamp duty is basically state subject. You have to refer the respective state law about the stamp duty. Whenever there is a additional capital that is brought in, and you need to pay the stamp duty for the only additional capital. In the current, whatever the question it is asked, that someone like you have 1 lakh capital and 25,000 is being taken out by the existing partner, and new partner is bringing 25,000 into the company, into the LLP. So there is no capital increase. So you don't need to pay any stamp duty for that. So you have to look at basically the state laws, how the state laws are provided. There's one more aspect as per the stamp duty I would like to share. If you look at the LLP Act, the partner can bring his contribution in form of cash and in kind, or in form of services, or in the form of property as well. Suppose if the partner is bringing in the form of a capital contribution in the form of a property. Recently, we had one situation. He has brought his land to the LLP as his contribution. Okay, unlike the regular partnership form, if you look at the regular partnership form and the stamp acts of the respective states, they say if the partner is bringing contribution as his capital and there is no stamp duty and no requirement to get the property registered in the name of the partnership form. There is no concept of partnership form legal entity having property registered in its name. It will continue to be there in the partner's name only whenever partner is retiring from that particular firm, and he will take back the property and there is no stamp duty again. Whereas in case of LLP, LLP is a legal entity. The property which comes to the LLP should be registered in the name of LLP. So if someone is bringing his contribution as a land, something, he has to pay the stamp duty, or LLP has to pay the stamp duty by getting the property registered in its name. So there is a stamp duty issue if the capital is brought in the form of immovable property, in the form of other than like services or other than cash or any other thing. There is no stamp duty for the property that is brought in. However, if there is a contribution that is getting increased, that extent you have to pay stamp duty for capital contribution. I think there was one more question was there.
Thirupal, whenever capital is increased, you need to have a supplementary agreement also.
Yeah. Whenever there is a capital increase is there, we need to enter into a supplementary deed and then file the Form 3. Form 3 is something like you have SH7 in case of company. There is a capital increase, capital reduction. Then all these things are there in the one single form called Form 3. So you should select that form and upload it. If you don't file, then it will not get updated your master data. So whenever you increase the capital, there should be an agreement. Once we should remember, so there is no concept called authorized share capital in the LLP. It is something like you have agreed to brought in that much money. That means it is like a subscribed capital. And then liability will continue to be there as long as you don't pay that money. And all your limitations, like limits, like for taxation purpose or audit purpose, it is based on the agreed contribution, not actual money that they brought in. Okay, so if you have agreed to bring in around 1 crore, you brought today only 10 lakhs. So there is a 90 lakhs liability that comes in your books. In the books also, as per my understanding of LLP provisions, though LLP provision allows you to have either accrual basis or the actual cash basis entries. You can have both entries, both accounting systems are allowed. And if you are recognizing through the accrual basis, you should recognize your contribution as 1 crore in the balance sheet. And other side, you should provide a liability of 90,000 or 90 lakhs to be receivable from a particular partner. If you are going with accrual basis, if you are going with a cash basis, you can recognize only 10 lakhs was brought in, the balance 90 lakhs. Whenever you call upon, he has to bring in. But as far as the MCA is concerned, it is 1 crore only for the calculation of fee purpose or any limits purpose or a small LLP, big LLP. It is as per the MCA, how much contribution that you have mentioned. Only that is the relevant to the MCA.
Mr. Mahesh Singh make an observation that this webinar always operates with great efforts and enthusiasm. Almost every question and query is covered by moderators, etc. No need to unmute for all. It will distract the program. Thank you, Sudhakar sir and Dipti ma'am. Okay. Whether recording this is fine. In case of transfer of dividend or profit to any other person, then in that case, tax on whose income is levied. We will discuss this with the taxation aspects. Okay, if profit of LLP is not withdrawn, whether they were considered. We have already answered this. Can the share of LLP be sold? We have answered this. Does a reclassification of capital required to be paid stamp duty again on the agreement? Does reclassification of capital required to be paid stamp duty again on the agreement?
Not required.
What is the reclassification of capital, Thirupal?
Not required. Not required, but still one observation here, as far as the supplementary deed is concerned, it is a deed, it is an agreement between the parties and then LLP as well. Since it is an agreement, there should be some legal backup for that. So that is the reason you can enter into an agreement on a minimum stamp paper like 500 rupees. This was insisted by the ROC across India because it is an agreement, let it be there on the stamp paper. Some 500 rupees sometime. If there is no capital increase, if just it is only the reclassification, ROC people are insisting, there is no specific provision, but they are insisting to have a minimum stamp paper like 100, 200 rupees or 500 rupees stamp paper, because it is an agreement between parties. They want to identify the date of execution based on the stamp duty when you have paid it. and execution when it is happened, it is a legal document. So for those aspects, they are insisting for minimum stamp duty.
Thirupal, one question from Mr. CA Anil Chakodi that he says, in case of a CA LLP form, if one partner found guilty by any authorities, then whether other partners are also required to bear the cost of penalty charged by the authorities like NEFRA or MCA, etc. I think this question is equally applicable to CS LLPs also. CS
Yeah,
LLP
for
forms.
everyone, it is written clearly in the LLP Act also, if the fraud or whatever it is identifiable and if it is from a particular partner and he will be held responsible, not the other partner.
There is a question, can you please re-explain the concept of increase of contribution due to yearly profit and forms to be filed with MCA?
Yeah, see, increase of authorization, it is similar to the, bonus shares. Tell me whether company issues bonus share every year whenever there is a profit. They don't do. But you have an habit being a regular partnership firm. Every year, profit will be distributed and credited to respective partners' account, either as a current account or the regular profit account. Because there is no reporting system, there is no problem. In case of LLP also, if you want to do so, you can do so. There is no bar. Distribute the profit every year and credit to the respective partners' capital account. If you don't want credit to the respective partners' regular account, like people are calling nowadays like a current account. So if you don't want to call it as a capital, if you want to call it as a capital account, then you don't have any option. By filing the Form 3 and entering the same in the form of an agreement and filing the same, paying the fees to the ROC, you can enhance every year also. There's no problem. If you don't want to do it, you can maintain the profit and loss account lifelong. There is no problem.
Yeah.
Can LLP purchase properties in the name of LLP, or is it the same as partnership where even property is purchased by partnership firm, property is registered in the name of the partners?
I think we have all seen this one. LLP it is a legal entity, perpetual succession, everything is there. It can acquire the property on its own.
Correct.
I think we can allow any participant to speak.
Now, there are many questions. If Sudhakar, you allow, I will go reverse actually, and top also certain questions are left. Very quickly, we have to cover now.
Sir, the questions, madam, they were left because to cover them in the next session.
No. I know. That they have said we already have.
See, Dipti, wherever repetitive questions are there, or the questions are not pertaining to today's topic, I'm just rolling through them. Okay, I'm taking up only those questions which are of today's topic.
Because like we have already executed supplemental agreement, only not able to upload LLP. That is fine. Whether
that is technical problem. That
whether contribution can be reduced.
Yes, of course you can reduce it. As per as the law, there is no
We will
process.
cover in incorporation that you want to say.
Yeah.
In incorporation. Okay. Okay, then let's allow others to whoever has the raised hand. IT department, allow everyone one by one who raised the hand. Let me just check who has raised the hand.
I think Neeraj Kumar, Kuldeep Shastri.
Yeah, allow Mehta first. 12 participants. Okay. IT department, one by one you allow.
Okay. Thank you.
Yeah, thanks.
Hello.
Yeah.
Yeah, this is Yogesh. Wanted to understand in what situation can the liabilities of partners be unlimited?
I think we covered. Yeah.
Yeah, this is basically if you are doing illegal business, then you will become unlimited liability.
So it will be only in
And
very special situations that would be involved.
Yeah, correct.
And also
Not a normal.
Not normal, yes.
Designated partner liability also when become unlimited. If the partner get reduced within timeline, we do not.
Yeah.
That time it will happen. Yeah, Mr. Yogesh, you are telling something further.
Yeah, no, I'm done. I just asked this question, so I think you answered it. Thank you.
Okay, thanks. Yeah,
Yeah.
next, please.
May I?
Yeah, please.
Yeah, thank you. Thank you, ma'am. And sir, just a practical and question to Thirupal sir. Sir,
Yeah.
what will be, the better approach of, acquiring funds from especially partners for getting, the business done in a smooth manner? And I think the debt approach is better way
Yeah,
because, if we're showing it as a debt and the interest is also,
Charge.
can be given to
Hey.
partner.
No, you can charge even interest over the capital as well. Income tax allows you, as income tax recognizes.
There's certain
LLP as a
limitation, I
form.
think, sir. Up to 10 or 12% only that.
Yeah, 12%, 12%. 12% is allowed.
Okay. Thank you. I mean, practical way, that's I wanted to
Yeah,
ask.
practical
Thank you.
way, I suggest you, since the debt is not considered for any, audit and other checks, so debt can be more if it is go.
Yeah.
See, there is one concept that I would like to tell you. In the LLP Act, one section allows you to borrow the money from the partners.
Okay.
That is no problem. See, you cannot borrow from others because of there is a banning of Unregulated Deposits Act 2019, wherein LLP Act also is covered over there.
Okay.
So one should be, aware of that particular section, very draconian section. That particular act is very draconian. There are penalties like 75 crores penalties, 100 crores penalties are there.
Oh,
So
my.
as if you read carefully of that particular provisions of that act, LLP also cannot borrow. LLP is also regulated like a Companies Act. You have a deposit rule 2, regulation
Correct.
rule 2(1)(c). There are total 19 transactions are there. For
Yes, sir.
LLP
Yes.
also they are given certain provisions over there. In that act
Oh.
it is given.
Oh. Yes, sir. Thank you.
From partners you can take. From partners you
Mhm.
can take. It is allowed.
Yes.
Can
Thank
I
you.
ask?
Thank you, sir.
Thank you. Please.
Hello.
Yeah.
Can I
Yeah.
ask?
Yeah.
Please.
Hello. So
Yeah.
yes, I have a question. Whether the LLP's PAN number will be received with incorporation certificate, or we have to apply it by
No,
separate.
now it is given in PAN and TAN, both are there. Both will be there in the certificate of incorporation.
But I have actually I have incorporated an LLP and I have not received PAN card with it, PAN number with it.
Right. PAN card they are not serving, I understood.
No, PAN number.
Number should be there
Actually, in the company's case, PAN number is already written in the incorporation certificate. But in
No,
my
for
case,
LLPs we are getting, madam. Maybe this is the technical error. You need to write specifically to the MCA people.
to whom I should
MCA.
to whom I should to MCA.
Yeah.
Okay, thank you so much.
So,
Yeah.
hello.
Yeah. Please go ahead.
First of all, I would like to thank you everyone. This was one of the best sessions that I've ever attended, and I thank you to the monitor as well, because all my answers have got cleared today. So thanks
Great.
for that. I just had a small query. So this is a one-off case. If there is a partner, the designated partner have to do the DIA3 KYC every year. So one of the partners have not done the DIA3 KYC. So what has happened is that he's not an active partner. So while filing form 8 and 11, we are not able to file that form. So what is happening is there are only 2 partners now. So because of this, the other partner is also getting, squeezed into the penalties. That's why I asked the question that how can a partner resign from a LLP wherein, nothing is happening and, it's like, it's just going on. So how can this be possible? Because the other partner is not speaking, or, he's not replying to the emails. So, and, we are not able to file the form. So is there any specific thing that we can do while
Yeah,
filing a form 3 or 4, or,
there is
resign the
no
partner?
DIR 11 and all concept in the LLP right now. Probably you can approach
Exactly.
you can approach the ROC and inform the ROC. This is the situation. If ROC allows you, like companies, they will do back-ended removal, appointment, all those things they are doing. No, if they are able to do for a LLPs also, it may help you.
Okay, that is only the Apart from
now,
this,
it
there
is
is no
outside.
nothing written in the law as
Legally, nothing is
specific,
there
right?
right now.
Yeah. Yeah, Mr. Hatim.
Thank you very much.
So do every DP must have a DSE?
Yes.
Everyone must have.
Yes.
Yeah. Yeah, please.
Two questions.
Your voice is not clear, Mr. Khanna.
If there is two partners, so both partner will be the designated partner.
Yeah.
Yeah.
Okay, and this second question is that in case of you have talked about the section 42, in case of transfer of rights, if some amount is transferred to the wife of the share of the profit or any dividend part, so who will pay tax on that amount, the wife or the partner?
Wife only, no?
Wife.
Okay. Next.
What is the benefit of incorporating an LLP as compared to a private limited company? Can I please ask?
It goes based on the, each case situation. See, I get some people, they don't want to borrow any money. They have enough money with them and they want to just be in the business, like real estate business and all. They want to park the money in the form of properties. And then I can suggest them to go for LLP because there is no borrowing, there is no fundraising that they are looking. So it is better to have LLP wherein you can save the dividend distribution tax, the one. The second one, like you and me practicing company secretaries, to have a limited liability associated to your business, you can certainly have an LLP instead of having regular partnership form because it saves you your skin from the unlimited liability. Of course, some liabilities are there like professional liability for professional misconduct and fraud and all will be there, but you can have it. So
I think
service sector.
Thirupal, we are
As
covering
compared to
this
private limited company. As
session.
compared to
Yeah,
private
that's
limited company.
what private limited company.
We will
earlier
cover in the session, Nayan, that comparison between LLP and private, it is there. So better we take at that time. We will cover like partnership firm and LLP and company comparison. Advantages.
The next session you mean to say? Next
Yeah,
session.
we will cover. Yeah. Because it requires
Okay, madam.
long thing, no? That's why.
Lot of this one, yeah. One question, like the partners cannot bring in the loan funds in this LLP. You said something like companies that private limited company in the private limited directors cannot bring in funds. Like that, similar way, the partners also cannot bring in the funds as a loan loan.
I told partners can bring in because one of the sections allows dealing with the partners. You can have loans also from the partner, and it is not written anywhere similar to that deposit rule where he should give a declaration. It is not a borrowed fund. No such declaration is there. Okay. However,
And
I told you to look at
mandatory interest payments. Mandatory interest payment is not there.
Not there. That's what is up to you. And I told you to look at the banning of what illegal deposit. There is a one act is there 2019. Okay, so that section covers even LLP taking money from the others. It is prohibited as per that act.
PML Act 2019.
Not PML. Unregulated banning of unregulated Act 2019.
Okay.
Yeah, I think we have covered all. Anyone is left? Hello?
Hello, ma'am.
Yes.
Yeah. Miss Rajeshri.
Ma'am, can you hear me?
Yeah, please.
Okay, thank you. So, sir, my question is, we see that there are majority of family-oriented business are there, which are operating presently in partnership domains. And now we are in the phase that, we would like to advise them to get it transitioned into LLP. So for better recognition, as far as what I can understand from LLP is that you get the benefit of company plus you get the flexibility of partnership. So I just want to quickly the faculty to add just a few points on do's and don'ts, while we get into the LLP, so that the precautions can be well taken care of in advance.
No, there is a session I think is going to have a detailed section. on these
Incorporation
conversions.
and conversions will cover.
Conversions. We will
cover.
certainly give
We-
you all those inputs while, in the session. Maybe
Yeah, we'll cover.
it will be there soon.
Okay, okay.
Yeah,
Thank you,
next.
sir.
Hello, this is
Ma'am.
Arunachalam. Can you speak?
Yeah.
Yeah, I am Arunachalam, C. Arunachalam speaking. First of all, I would like to congratulate the format. And today's this thing was very useful and excellent, excellently organized. Particularly, I thank Mr. Sudhakar sir for the way he interjected and when the subject was fresh in memory. So at the time itself, we asked relevant questions. I thank him for that. And for the excellent presentation, Nayan madam also I thank. And madam, is there any possibility that you made a beautiful comparison between partnership and LLP and LLP with private limited and one-person companies? Is it possible to share those things? Because those are all the basic things which when clients when you try to convince a client, so we can tell them these are all the things. Based on that, they can take an informed decision. So that will give us a gist that way. If it is possible, if you can share that, that will be a great help, number one. And I have few questions to ask to Thirupal sir. Sir, can I ask sir one by one?
Please, quickly.
Yeah, the first one is that, sir, online e-commerce platform, can LLP do that?
Yeah, can be done. No
They are
problem.
not barred, from like you said,
Yes,
NBFCs are barred.
No,
Online
online
e-commerce.
it is. Yes.
Online.
Number one. And for to become a DP, is there like an independent director and they have to
No
qualify
qualification.
exam? Or to become
Only
a
should
DP,
be
is there any?
person competent to enter into a contract.
Okay, that's the only thing. There is no other objective questions and all. He has to pass any exam and
No,
all.
no.
No.
Nothing. Okay, sir. Then the one more question is, sir, you were telling the initially while forming the LLP, the partners enter into an agreement among themselves.
Yeah,
At that time, they don't enter into agreement with LLP.
no problem.
That is not yet formed. Then LLP is incorporated. Then subsequently, any change in partnership, either a partner exits or a new partner joins. Okay. At that time, you are telling that a supplementary agreement has to be entered. That supplementary agreement, is it a single agreement where the new partner enters into all the existing partners as well as LLP? Or is it a two agreement where the one agreement is between the new partner and existing partners, and other agreement is between new partner and LLP? That one. And if a partner is exiting, whom should he enter into agreement? What kind of agreement
See, there is a form 13. Whenever partner would like to exit from the partnership firm, like you have a Companies Act 168, you are supposed to give a notice. So there is a form 13. The partner is supposed to give 1 month notice that he would like to exit from the LLP. To all partners, he should give the notice.
Okay.
So there will be single agreement wherein LLP also will be party to that agreement, and other partners existing and also outgoing and also the new partners together will sign single agreement and a single date. Okay, because if you change the dates or have the more agreements, you need to file more documents like Form 3s and Form 4s.
Okay.
Ensure to have only one agreement as a single agreement and a single day, and whatever the stamp paper is required based on the capital, acquire only once.
So Form 13 is only for the giving notice for a existing partner to exit.
Yes.
But is there any other form for new partner to join?
Yeah, new partner has to give, if he's going to be designated partner, he should sign one Form 9, LLP 9.
Consent, that is consent form.
1 minute, 1 minute. The Thirupal, these all will be covered in our sessions. अभी तो incorporate नहीं किया है, partner आ रहा है, जा रहा है, सब question.
No, today that point came, so I thought that is covered.
There are formats available, sir. There are formats available that should be given. Okay, and then they should give the consent also accordingly.
Okay. Thank you very much, sir. Thank you very much.
I'll
Nayan madam, if you can share that.
I'll request all the participants, incorporation, admission partner, execution.
Concept. You can focus on concepts. Yeah.
Yeah, please,
Okay.
today's topic only. Okay, thanks. Yeah,
Dipti
anyone?
ma'am, can you hear me?
Yeah, please.
First of all, I would thank Ms. Nayan Handa ji for conducting such a beautiful webinar.
My question is, can lawyers can create LLP?
Look with your bar council. A bar council probably, I think I've seen some law firms having LLPs also. I don't know whether they are really registered with the bar councils and all.
No, as far I know, Bar Council gives us the license to practice, and Bar Council does not prohibit to make us partnerships. So my question is that, can advocates form LLP?
Yeah, advocates can form an LLP. The question is that whether an advocate can continue to be there as a designated partner, and also other side he practices his own practice, that you have to examine. Suppose I am a company secretary in practice, I can also create one LLP where the LLP doesn't do any secretarial practice. But I can't be designated partner over there. I can be partner. That's all.
Okay. Thank you.
Thank you. Anyone else left or?
Yes, hello, hi, this is Divya.
Yeah,
I just have
yeah,
a very
Miss Divya. Yeah.
I just have one question is that are the LLPs allowed to give loans to body corporates, like to normal companies?
See that you need to examine the deposit provision, that 2 clause 21C only 6 allows the any money from any company. LLP is a body corporate. Throughout those 19 clauses of deposit rule, LLP is not covered. However, LLP can give in the form of like customer advances, all those things can be given, not as a loan. It
Not
will
as a-
violate the deposit.
Sir, Karishma, this side, just want to know, as you have said that there is a capital increase due to the share of profit, then Form 3 is to be filed.
Yes.
And on increased capital, then stamp duty is to be paid through Form 3 and supplementary
Yes.
deed is to be changed.
No, Form 3, there is no stamp duty payable under Form 3, but only agreement should be revised, and as per the agreement, you have to pay the stamp duty.
Okay, so it's every year has to be do.
Yeah, if you want to increase every year your contribution, you have to do it.
But want to know one more question. Sir,
Karishma, we will cover all this. Dear, incorporation होने दो, फिर share capital लाएंगे. अभी तो incorporation भी नहीं किया है हमने LLP का.
Acha, one more thing. Is there any form for appointment of auditor in LLP?
नहीं, कुछ नहीं ऐसा फॉर्म नहीं.
Okay, thank you. Thank you.
I think we will conclude because people are asking the questions of next sessions only. So sorry, but whosoever has not been answered, and if it is, you repeat the question in next session. Okay?
So Dipti, before you conclude, can I say that in the next webinars, what are the chapters we are covering? In the next webinar, we are going to do about the incorporation, partners, partner relationship between the partners, liabilities and contribution of the partners. Then week thereafter, we are going to discuss about the SBO LLP rules 2023. Week thereafter, audit, accounts, investigations, winding up and resolutions. And week thereafter, conversion and foreign conversion of an LLPs into companies into LLPs, etc. Plus FDI into LLPs. So this is what is going to be. And so for next webinar, participants may prepare and come about the incorporation, about partners, their relationships, liabilities, accountabilities, responsibilities, and contributions.
Yeah, please, we humbly request for a good session. There should be limited to the topic of that session only, please. Okay? Yeah, thanks everyone. Let's see next week with the incorporation and other topic we mentioned. Thanks a lot.
So thanks very much, Thirupal, and since
Nayan,
incorporation.
thanks for very good presentation. Actually, all the questions discussed was very well covered by you in the your presentation.
Correct.
So now next time, I think people should first go through that presentation, then we should allow the question, because the questions are coming. It was very well covered by you. Thanks for that.
Yeah.
So Thirupal, since incorporation, we are actually overlapping into next week, and I'm requesting you, unless until you have a commitment for next week, kindly join us as a panelist for next week also.
I will let you know, sir. I will try. Right now, I don't have. I will see.
Okay.
My schedule now. Okay. I'll confirm.
Please do let me know. Please do let me know. Okay.
Thank you.
Yeah.
Thank you very much. Thank you.
Thank you,
Thank you.
madam, for providing
Thank you.
opportunity to
Thanks
share.
everyone. I hope Mr. Nirav is satisfied. Thank you.
Thank you, sir. Sudhakar, sir. Thank you, ma'am.
Thank you, Thirupal.
Thank you. Bye.
Bye.